right, everyone. I am Shanna Welch-Levin, your Southern California real estate attorney with SoCal Realty Law. Here at SoCal Realty Law, we represent real estate investors and real estate professionals. We protect the rights of real estate investors and professionals. We represent landlords in the unlawful detainer process, and more so, we try to help landlords avoid the unlawful detainer process. We are showing up monthly for you landlords and property managers and property investors to make sure that you have the most current updated information. Even if you don't need or use our services, you are more than welcome to attend our webinars and take advantage of all of the information that we're providing today. I want to give a huge shout out to my team. In particular, I have a great unlawful detainer department. We have our paralegal, Lisa Manriquez, who's been doing unlawful detainer work with me since 2012. We have our newest member of the staff, Jim Delaney, who is an attorney who has over 10 years of experience and is now holding up the unlawful detainer department to make sure that things move smoothly and more quickly than with just me at the helm. And then we have our other paralegal, Fabian Garcia Brown, who is amazing in our litigation department and backs up our unlawful detainer department as well. If you wonder what else SoCal Realty Law does, we also do residential real estate litigation, such as fraud litigation, easement and boundary line disputes. We do some title transfers, title transactions that are, smaller transactions like for sale by owner and parent to child transfers. And if you have any questions about any other kinds of law that we may or may not do, or if you need a referral, please feel free to reach out, or you can ask a question at the end if you want to know if we do something in particular. So today we'll cover, once again, the new laws for the California Tenant Protection Act, the changes to our old AB 1482, our dear and adored tenant just cause law and rent cap law. And then I'm going to add in some more of a deep dive about the new security deposit law, because I've gotten a lot of questions about it and how it works. And then we will talk about source of income discrimination in California and what to watch out for with regard to, considering renting to a tenant who might have a rental subsidy and what to be very careful about. And then a huge shout out to our marketing assistant, Jessica Sendejas, and she's the one who sends you all this invitation for this webinar and makes sure that you get the confirmation with the link, and she makes these webinars happen. So thank you, Jess. All right, so our new changes to the California Tenant Protection Act went into effect as of April 1. And these are some pretty dense changes. The summary bullet points, and then we'll go into depth, include changes to terminating a tenancy for landlord's intent to occupy. If a landlord intends to occupy the premises, that is considered a no fault just cause. The tenant is not at fault. And so the state is getting a little stricter about landlords using this reason in order to terminate a tenancy. We're talking about the substantial remodel and demolition just cause, because again, that has been used quite a bit, and the state is cracking down on how broadly it can be applied and requiring landlords to add more information in their notices and provide more evidence to tenants that they are in fact doing the substantial remodel. We'll talk about some of the new enforcement remedies. You'll see an uptick in the number of attorneys who are willing and able to take tenant cases to represent tenants in defense of an unlawful detainer or against a landlord, because of the new changes in the law that provide a new right to attorney's fees and punitive damages and a private right of action for the tenants to enforce the law. And then we have the additional legal remedies to enforce the rent cap portion of the Tenant Protection Act. So let's start with landlord's intent to occupy. So under the new law, when a tenant wants to use their moving into the property as a reason to terminate the tenancy, first and foremost, and this isn't a change, but just to be knowledgeable, that the term of the lease has to be at an end. So if you have a 1 month lease, I'm sorry, if you have a 1 year lease, you can't use a no fault just cause to terminate the tenancy in the middle of the 1 year term. You have to wait until the tenancy goes month to month. So you could give a notice 30 or 60 days prior to the end of the term in order to take action, or after the term ends and the tenancy is month to month, then you could give notice. But if this is the reason you're using, then the landlord has to intend to occupy the premises for 12 continuous months. And once the tenant vacates, the occupant needs to take occupancy within 90 days. So the landlord could also be using the premises for occupancy by their spouse, domestic partner, children, grandchildren, parents, or grandparents. But it does have to be a related person or people, and they have to move in within 3 months and stay there for a year. Now, there's a special part of this rule for mobile homes. Then this is a state law, because what I'm about to tell you with regard to mobile homes actually is applicable for all non-exempt tenancies for the city of San Diego and for the city of Chula Vista. But for the state of California, for leases in a mobile home, the landlord has to include as language in their lease that the tenant agrees to, that the landlord may terminate the tenancy when the landlord wants to move in. Or alternatively, the tenant has to agree in writing to this. So like if you have an old lease and you want to add this provision, you just have to get the tenant to agree to it. So you do an addendum and you have the tenant sign it. But for new leases, we are recommending this provision in all leases. And just to reiterate, it's a provision that states that the tenant agrees that the landlord can terminate the tenancy if the landlord wants their family to move into the property. Okay, there's no harm in having that in all of your leases, and just in case the law, you're not aware of the law in your area, you might as well just have this in your lease. Also, the state has excluded from application of this. So if there is a vacant unit on the premises, or if the person, the family member who intends to occupy the unit, occupies another unit on the premises, meaning that, you know, that would appear that the landlord is using this provision inappropriately to get a tenant out when the landlord doesn't really need to use that unit. So the state has created this, this part of the law to prevent landlords from using this law to inappropriately remove tenants. So if the occupant's already occupying a unit on the premises, or if there's another vacancy where the tenant could be moved to, or that the landlord could occupy, then you can't terminate the tenancy under this reason. All right, so then the notice has to contain the names and relationship of the intended occupants, and you have to tell the tenant that the tenant has the right to request proof of how those people are related to the landlord. And then if the occupant fails to take occupancy within 90 days or doesn't occupy for the full 12 months, then the owner has to make sure to re-rent the premises to the tenant under the same terms that were in effect at the time the tenant vacated. There are some new definitions for this new law of the intended occupant and owner. So those definitions, a lot of it involves the interpretation of the word natural person and how much of a ownership interest that person has to have in the premises. This gets very technical, and as I read it more and more, I find that if I had to litigate this issue, I would find it very confusing. I think that I'm not sure where they got this wording from, but if you really dig into it, I have a lot of questions. I won't get too technical with you though. So the natural person has to have a 25% recorded interest in the property. So that means you could pull the public record, the title of the property, and you could see this person's name on title, and you could see that they have a 25% interest in the property. Or the natural person has a recorded interest because the property is owned by a family that owns 100% of the interest. So that could be a property that is in a family trust, and maybe they're a beneficiary. That gets into the next part where they further define a natural person. But then the third definition here is an owner who is a natural person whose recorded interest in the property is owned through a limited liability company or partnership. So you can use a limited liability company as part of your estate plan, and as long as that limited liability company is owned by a natural person as defined below, then they would qualify to use this landlord's intent to occupy as a reason to terminate a tenancy. Getting a little complicated, but hang in there. So then they further define natural person. A natural person is a settlor or beneficiary of a family trust. So the settlor part I get, that's the trustee. That's the person who creates the trust, or the person who is basically the owner of the property. It's in a revocable trust, the trustee is basically the owner of the property, the person who governs the property, the landlord. That's usually the settlor as well. Just, different terms for the same thing. Beneficiary of a trust is a more it's a person who you can't necessarily determine from public record. You can't look this up. It is usually obvious in the terms of the family trust. So if you get a copy of someone's family trust, it's because they've given it to you. It's not a public record. So the beneficiaries of a family trust are not public record typically. And so if we're trying to determine whether someone is a natural person because they claim to be a beneficiary of a family trust, then that person is going to have to give a copy of the family trust to, for instance, to the tenant who is challenging their right to terminate the tenancy, or the tenant who claims that they don't have the qualification to occupy the premises and terminate the tenancy. Okay, so then again, if it's a limited liability company, the natural person has to have a 25% ownership interest in the property. You could see how a limited liability company, an operating agreement, an ownership interest under an LLC could give to different owners different interests in a property. And so you might have to, as a landlord using this reason to terminate a tenancy, you might have to give the tenant a copy of your LLC's operating agreement or the minutes and decisions of the managing members of the LLC. So you might have to disclose some private information to the tenant. They define a family trust, which I don't think there's anything exciting there. And then they define a beneficial owner. So then so now we're talking about a beneficial owner means a natural person or a family trust for whom directly or indirectly and through any contract arrangement, understanding, relationship, or otherwise, any of the following applies. That they either have substantial control over a partnership or limited liability company, or the natural person owns 25% or more of the equity interest of the property or limited liability company, or the natural person receives a substantial economic benefit from the assets of the partnership. We're getting very, very ambiguous in these definitions as to who the natural person is and who can use this landlord's intent to occupy. I can think of any number of scenarios where this could be a huge issue, a huge legal issue that a tenant could potentially use in their favor to claim that the person does or does not have the right to occupy, and to dig into a bunch of private information through the litigation process, the discovery process, and try to, you know, just kind of invade the information of the landlord that would otherwise be private. So yeah, it opens a door here with these definitions that I think is not only interesting, but also potentially cause for some heavy litigation for some people who have this issue. All right, I'll move on. I noted that there was no amendment or clarification of subsection 1946.2 B2B. So that's this highlighted part where a no fault just cause that you can use to terminate the tenancy is the withdrawal of the property from the residential rental market. And that provision has always been very open and general. And the question is, well, if you're going to withdraw it from the residential market because you're going to sell it, which is usually the scenario, you want to sell the property, so you want it vacant, so you get a better price for it. You can fix it up before you sell it. You're withdrawing it from the residential rental market. You don't know who you're selling it to. Does your obligation to withdraw it from the rental market carry through to your buyer? What if you sell it to a buyer who then immediately puts it back on the rental market? Is there some reason why the tenant might have a claim for violation of this law because the property was only temporarily withdrawn from the rental market? I get the question also, how long do you have to withdraw it from the residential rental market? It's very unspecific. There are some other laws that you can compare it to, and you can come up with, usually when I look into it, I generally would argue that as long as it's off the market for a year, then you've probably complied with this provision. Some would argue it's forever, which I would disagree with that, because I think that's against some of the constitutional principles of putting property to its highest and best use. All right, but I'll get down from my soapbox. I want to point out that it's very, very general. I haven't seen any litigation of this provision, and I will expect to see something in the future about, you know, what does it mean? Okay, so then that wasn't changed, but what was changed is the guidance within the statute and the requirements within the statute if you're terminating the tenancy based on the landlord's decision to substantially remodel or demolish the premises. So the substantially remodel definition is that the tenant cannot stay in the property for at least 30 consecutive days, cannot safely live in the property for at least 30 consecutive days because the landlord is replacing or substantially modifying structural, electrical, plumbing, or mechanical systems, and that these remodels require a permit. And apparently, I'm not a contractor, but apparently when you're abating hazardous materials, that does not always require a permit. So there's a provision in here that if you are abating hazardous materials, you have to be doing it in accordance with federal, state, and local laws, and you can just provide a copy of the estimate from the contractor who's doing the abatements, and that will fulfill the requirement here. But you have to provide a copy of the permits or the estimate to the tenant. And let's see, you have to provide them with a written notice terminating the tenancy for just cause with the following information: the statement informing the tenant of the owner's intent to demolish or substantially remodel, and then a quote, a specific statement that if the substantial remodel of your unit or demolition of the property as described in the notice of termination is not commenced or completed, the owner must offer you the opportunity to re-rent the unit with a rental agreement containing the same terms as your most recent rental agreement with the owner at the rental rate that was in effect at the time you vacated. You must notify the owner within 30 days of receipt of the offer to re-rent of your acceptance or rejection of the offer. And if accepted, you must reoccupy the unit within 30 days of notifying the owner of your acceptance of the offer. Okay. Once people move out, you often lose track of them. So a tenant who wants to reoccupy the premises should make sure that the landlord has their forwarding contact information. Typically, that's something the landlord will want so that they can process a security deposit. So, and it is an echo of the same policy that you saw in the other changes for occupancy by the landlord, where if the landlord's not going to occupy for a year, they have to offer to re-rent it back to the tenant. Okay. And then more procedurally, you have to include a description of the substantial remodel, a copy of the permit or permits, or a copy of the signed contract with the contractor that's going to perform the abatement of hazardous materials. And then a notification that if the tenant is interested in reoccupying the rental unit, that they need to inform the owner of their next address and make sure they keep their phone number and their email updated with the landlord. All right, so that's a lot. Those are a lot of changes. We've had to update all of our notice forms. And then what I mentioned before, there will be lots more attorneys getting into the business of representing tenants, and here's why. In the past, this law, the remedy under this law is that if you failed to comply, your notice was void and your eviction would fail. If you went to court and the tenant could prove that you violated it, the tenant would win. Under a lease, you might have to pay the tenant's attorney's fees if the lease provided for attorney's fees. Now, the statute provides for attorney's fees. So if you violate the law, not only do you lose your eviction, you also owe the tenant any actual damages that they incurred. So if they had to move out, or, think of any scenario where they might have paid some money out of pocket to either move their belongings, protect themselves. Those are actual out-of-pocket damages that the landlord has to reimburse them for. They get an award of their reasonable attorney's fees and costs. And then if a court or a jury, a judge or a jury, finds malice, bad faith, intentional conduct by the landlord, the tenant may be entitled to their treble damages, which is 3 times their actual damages, and punitive damages, which is an unknown number based on a variety of information that a judge or a jury is allowed to take into account when awarding punitive damages. The court can also issue injunctive relief, meaning they can stop an ongoing eviction. And if the state or the city or the county wants to take charge of representing a tenant, they can do so as well. So those are the new remedies. And finally, I want to just put out a reminder to all of you who might be considering at-fault evictions. That an at-fault eviction is where the tenant is at fault. So these are your non-payment of rent evictions, and in particular, these are the ones where the tenant can cure the violation. But I would do these for all of the at-fault evictions, even illegal subleasing, which is not a curable one. So there are some curable and non-curable at-fault evictions. The point here is that you now have to do 2 3-day notices. So you do a 3-day notice to pay the rent, and you have to do a 3-day notice to quit. Or you do a 3-day notice that to notify them that they are illegally subleasing, and then you do a 3-day notice to quit. Or a 3-day notice to cure the breach, like they've changed the locks, you want them to change the locks back. So it's a 3-day notice to change the locks and then a 3-day notice to quit. You have to serve them in succession, not at the same time. So you wait out the 3 days. If they don't cure the breach, then you can serve the notice to quit. It's a pain in the butt. We have a dedicated process server who we keep really, really busy now, and basically, you know, it's double the amount of serves as we used to do. And then the changes to the rent cap are also mostly in the enforcement remedies. The rent cap reassessment happens based on numbers that are gathered in April. I'm sorry, this isn't the change yet. Let me just give you a heads up. Every year, the California rent cap gets reassessed by the state, and it's based on the Bureau of Labor Statistics assessment of the consumer price index, and that's basically measuring the rate of inflation. So from April to April every year, they measure the rate of inflation, and if inflation has gone up, they can increase the rent cap up to 10%, which is where we're at now. We're at the cap. It's been at the cap for a while. I know, John, you pointed out that in some counties, it's not at the cap, it's below the cap. And there is a place to look that up. So wherever you're at, you want to make sure to look up what your rent cap is. In San Diego County, we're at 10%. If inflation has gone up this year, we'll stay at 10%. If it has gone down, you might see it, the rent cap, reduce below 10%. We won't know that until usually June is, you know, maybe end of May, but early June. And it doesn't go into effect until, gosh, I hope I get this right, July 1, or rent changes that go into effect as of July 1. It might be August 1. I'm going to go with the earlier date just to be on the safe side. So changes in rent as of July 1 need to follow the new rent cap. All right, so the change in the rent cap law is that there are new enforcement remedies. The tenant can recover their actual damages, which is the out of pocket, whatever they have overpaid for rent. If the increase in the rent was beyond the rent cap, beyond the 10%, then the tenant gets that as their actual damages, and then the court can treble that, multiply it by 3, and they can get their attorney's fees and costs. Also, the state, the city, and the county can enforce it if they see fit. Yeah. All right, so also on April 1st, 2024, the City of Chula Vista updated its laws, its local ordinance, its tenant protection laws, very similar to what the state has done. They're basically echoing and going usually a step farther than the state has gone. So in Chula Vista, they've updated their definition of an occupant owner. You'll see similarly, they have this 25% recorded ownership interest, or if the interests are related family members, or if a natural person is the owner of the LLC. So they've just kind of clarified that a little bit. Their no fault just cause intent to occupy. This is the landlord's intent to occupy, very similar to what we've already gone over. They require the owner to move in within 90 days after the tenant vacates, and they must remain for 12 months. Also with a substantial remodel, the premises have to be uninhabitable, so it has to be a safety issue. The tenant cannot live there safely for at least 30 days. Okay, and so a little bit more carefully, let's look at it. So these are for residential rental complexes that are Updates for a residential rental complex, not, sorry, these are for all non-exempt properties. What I mean to say is that in Chula Vista, they have two different definitions of the properties that are subject to their law. They have residential rental units and residential rental complexes. And a complex is a non-exempt property that has more than 3 units. A rental property may be subject to the Chula Vista law if it is less than 3 units, if it is not owner occupied. So, you know, I like to look very carefully at the statute to confirm whether it applies to a particular property, because it is segmented and difficult to follow. But basically, you know, a duplex that's owner occupied may be exempt from the Chula Vista law, but a duplex that's not owner occupied is subject to it, is non-exempt, but there's a different part of the law that applies more stringently to rental complexes, which have 3 or more units. But so these changes apply to all non-exempt properties, so those non-owner occupied duplexes, as well as the rental complexes. If the tenancy is being terminated because the landlord is moving in, the tenant gets a notice of the intended occupant. So the written notice has to identify the name or names and the relationship of the intended occupant to the landlord. The written notice also has to include notification that the tenant has the right to request proof that the intended occupant is the qualified owner occupant. And the proof shall be provided upon request and may include an operating agreement or other non-public documents. Then we have some changes to their part of the law on substantial remodel or demolition. If it's not commenced or completed, if a substantial remodel of your unit of the property is not commenced or completed, the owner must offer you the opportunity to re-rent the unit. So that's what you have to inform the tenant about, that the tenant has the right to move back in if that substantial remodel doesn't happen. The tenant has the obligation to notify the owner of their interest in that offer within 30 days of the offer being given. And the tenant has to, the notice has to indicate to the tenant that the tenant has to provide their forwarding address, their telephone number, and their email address. Okay. The notice also has to describe the remodel, the approximate duration and date of the demolition, if it's demolition instead of remodel, and either a copy of the permits or a copy of the signed contract for abatement of hazardous materials. This should all sound very familiar because all of these provisions are very similar and yet written slightly differently. I do not really intend to go over all the City of San Diego information because none of that has changed recently that I know of. And we've gone over it before in prior webinars, which have been posted on our YouTube channel. So just be aware that there were laws passed in the City of San Diego back in June, when it became effective in June 2023. There is a new notices that need to be served. There is a tenant protection guide that needs to be served. We serve the tenant protection guide on exempt and non-exempt properties under this law, even though it's only required for the non-exempt properties, because the guide itself explains whether the property is exempt or non-exempt. And then we also do the required notice of exemption or notice of non-exemption. But be aware that at this time, you have to have the notice language in your lease. So for any new lease renewal, any new tenancy, it's no longer just a notice that you give. If you now have to have it in your lease. There's still no landlord portal on the San Diego Housing Commission website. They are still working on it. who knows when that's going to happen. I meant to mention for Chula Vista, rather than doing a landlord's portal and being technical and digital about it, they have a form and some information on the city's website as to how you would notify the city. They do require the city to be notified of evictions in Chula Vista that are not exempt from the law, and they have instructions on their website as to how to notify the city. Okay. All right, so I had some questions. I've had many questions, in fact, about the new security deposit law. If you were in the last webinar, you remember the question was whether pet deposits are included in the limitations under the new law. And I said, I think so, but I wasn't sure if there might be any exceptions. So I wanted to look into any exceptions. And I was right that it, you know, what you have to do when you're calculating how much security deposit you're charging, you have to add everything up. The definition of security is any payment, fee, deposit, or charge, except as provided in section 1950.6. I'll tell you about what that means. So any payment, fee, deposit, or charge that is imposed at the beginning of the tenancy to be used to reimburse the landlord for costs associated with processing a new tenant, or that is imposed as an advance payment of rent, or to be used for any purpose, including but not limited to default in payment of rent, repairing damages to the premises that are not ordinary wear and tear, cleaning the premises upon termination of the tenancy to return it to the same level of cleanliness as at the inception of the tenancy, and to restore or replace any personal property or appurtenances that were part of the tenancy, exclusive of ordinary wear and tear. So this does include a pet deposit and many other charges. That reference to Civil Code 1950.6 is a statute that excludes rental application and screening fees from part of the security deposit. So the new law provides that security deposits are capped at 1 month of rent. This is the law, capped at 1 month of rent. However, they've provided some exceptions. The state has provided some exceptions. One exception is a tenant who pays in advance for up to 6 months of rent. A landlord can charge. If a tenant will pay 6 months in advance or more, then that's fine. Less than 6 months advance rent payment is not allowed, but 6 months or more is allowed. And that's for a lease term of at least 6 months. So it has to be a lease of 6 months and the tenant pays 6 months or more in advance. Mutual agreement for the landlord to make structural, decorative, furnishing, or other similar alterations. I have never seen this before, and this is for residential, because you see this a lot in commercial, but for residential tenancies, if the landlord and tenant agree that the landlord's going to make some changes to the property, then the landlord can take an upfront fee for their mutual agreement to do those things. Now, what the part of the law that's applicable to most landlords who own, you know, 2 rental properties, not more than 4 units, you can take 2 months of security if the landlord is a natural person and owns no more than 2 rental properties, but in those rental properties, it can be no more than 4 units. So if you own 2 properties, no more than 4 units, you can take 2 months of security. You also have to be a natural person. We talked about how that's defined. The question last time, and I've gotten this question multiple times since then, is whether the 2 properties includes properties outside of California. My opinion, my legal opinion, is that it only counts properties inside California. I'm saying it's probably limited to account of how many properties you own inside California, because the definition of a landlord, which in the civil code is a person who hires, Civil Code 1940, is dwellings in California. So the definition of a landlord under all these statutes is someone who leases property within California, who hires property within California. And then also keep in mind that service members may only be charged 1 month of security regardless. You can't charge a service member more than 1 month of security, no matter what kind of landlord you are or how many properties you own. All right, and then one more issue I wanted to touch on, and this is the last one, and then I'll get to some of your questions. Source of income became a protected from discrimination under the California Fair Employment and Housing Act, and it includes subsidized rent. So I'll give you an example of why I find this interesting. Of course, I would not want people to be discriminated against because they have Section 8 subsidized housing or VASH subsidized housing or any other program. And the city of San Diego has some very explicit restrictions against discriminating against people who propose to rent under Section 8. I had a landlord who had a tenant already in place who was paying regular rent, didn't have any subsidy. And then that tenant had something happen in their life and they asked if the landlord would cooperate with a rent subsidy so that they could continue to live at the property, because otherwise they wouldn't be able to afford it. And the discussion was, why does the landlord, the question is whether the landlord had to cooperate with this proposal. And in that particular instance, if the landlord refused to cooperate with the proposal, and there were lots of reasons. I mean, and it had nothing to do with having anything against a rental subsidy. It was more that when you agree to a Section 8 program or a rental subsidy program, they usually have addenda that you then have to sign that change the terms of the existing lease. And so the question was, why does a landlord need to agree to change the terms of their lease in order to allow a tenant to accept a rental subsidy? And it's because you can't discriminate based on source of income. Well, why does the government have the right to change the terms of my lease, even if, or it doesn't seem like changing the terms of the lease or refusing to change the terms. It doesn't seem like refusing to change the terms of the lease is discrimination. It is really just supporting the idea that you don't have to change the terms of your contract, right? I mean, I understand where the person is coming from in challenging the idea, but let's say that you refuse to accept the program and you refuse to sign the forms, and then the next month the tenant can't afford their rent and you go to evict them. Their defense is that you have now discriminated against them based on their source of income because you refuse to cooperate with their subsidized housing. And then I was very interested to learn in my renewal of my real estate broker's license that according to the California Civil Rights Department, which was formerly the Department of Fair Employment and Housing, of course, they define income as subsidized rental payments, regardless of whether they are paid directly to the tenant or to the tenant's representative or to the landlord. So it's income regardless of who it's being paid to, if it's for the benefit of the tenant's rent. They say that refusing to cooperate with the housing authority by failing to complete paperwork to participate in the HUD program or complete required inspections or considered violations. If a current tenant qualifies for a Section 8 voucher, a landlord must in good faith engage in the process to qualify to be a Section 8 approved landlord. If an existing Section 8 tenant has a new landlord Due to the sale of the property, the new landlord is required to engage in the process to qualify to be a Section 8 landlord. And this is based on the regulations of the California Civil Rights Department and the way that they are enforcing those regulations. So that's a much better answer than I had last year when I was working with the client with these very questions. And then to add on, there's a new law that says that the landlord is prohibited from using the tenant's credit history as part of the application process without offering the applicant the option of using alternative evidence to demonstrate that the tenant has the ability to pay the rent, such as a rent subsidy program. All right, so I know that's very interesting and complicated. I just wanted to put that out there, and then if you guys have some questions, I will do my best to answer them.